To conclude this important session, we now invite a distinguished legal expert, Mr. Chander Mohan Lall, Senior Advocate, Bar Council of Delhi, brings extensive legal experience and expertise. Today, he will speak on negligence, liability, consumer and operator rights, and legal documentation. Ladies and gentlemen, please welcome Mr. Chander Mohan Lall. Thank you.
So, good evening and thank you for this invitation for speaking to this august audience, coming straight out of court. And one of my first challenges, adventure challenges, was how to make a legal point not so scary and a little bit entertaining. So that would be my attempt. A lot of the effort that has been put in is not by me. It's by my junior and also by artificial intelligence. So if you see a general trend, I don't take the credit for it. So I'm going to cover, a lot of speakers before me have spoken about, an adventurer spoke about it, insurance, etc. Also rescue operations. All of this leads up to, obviously, legal challenges. When does an insurance company doesn't pay is open to a legal challenge. What are the safeguards that you must take as adventure tour operators to secure yourself from those legal challenges? Trust me, if you think that shark attack was bad, you don't want to be in a court. You'll suddenly want that shark to come and attack you, because in courts, there are many more sharks who won't just bite your leg off. So I'm going to cover some of the aspects on negligence versus liability. When does that? That's an overview. I'm going to speak about how should your, contracts are important because you enter into waiver agreements, etc. What kind of contracts will live up to legal scrutiny? I'm going to talk about the Consumer Protection Act, which is a civil liability which may put some costs on you through the Consumer Protection Act, and all users of adventure services would be termed as consumers. And then I'm going to talk about, obviously, in any adventure tour, and especially with the climate change that we discussed, there's going to be acts which are way beyond our control, and that is going to cause harm which we could not have anticipated. What is the effect of that harm is something that I'm going to be discussing. So negligence versus liability. When does negligence convert into liability, and what constitutes negligence from a legal perspective is what I'm going to discuss next. So there is an element of duty of care. Every operator has a duty, even without a formal contract, for the duty of care to your client. So don't think that merely because you have not contracted and once you provide adventure tour operations, your client becomes an essential part of you, and therefore you have a duty of care by law. If you don't meet reasonably prudent adventure operator safety requirements, you may be breaching that duty of care. So you need to be careful. Just to give you an example, you don't have an emergency preparedness, or the equipment that you use is not the appropriate equipment for the activity that you were going to indulge in. When does that duty of care become connected to the harm that may have? It's the causation effect, that the breach must directly cause the harm. If the same injury would have occurred regardless of the breach, causation fails and the entire claim collapses. So where you have made the breach, there must be a causation to the accident. It can't be that you weren't carrying medication or a headache pill, but you had an accident on a raft. So there's no real causation there. And then eventually it is injury that must have taken place. If there is no injury, then there would be no liability leading up to that. What are the types of liabilities in adventure tourism? Is fault-based negligence. Operator failed to meet the reasonable standard of care, most common basis for at least consumer forum complaints. It's very easy to then that is where your entire checklists come in as to what was that duty of care and how did you ensure that the fault didn't happen. And then that also, under this, I still haven't gotten used to this Bharatiya Nyaya Sanhita. Uh, they've changed our sections. If anybody who's practiced law, you never change sections. We kind of remember sections, and I still, when I argue cases, I rely on the old, criminal acts and the. So under the Bharatiya Nyaya Sanhita, section 106, causing death by negligence, I'll be talking a little about that. Endangering life, and cheating as a concept when you don't give out the information to your client. And then I'll be discussing that a little bit more in detail. So there are also not just civil liabilities or consumer liabilities through a consumer court. You could also be held liable criminally if you don't put that appropriate duty of care. So and that becomes pretty serious, because in an adventure tourism sport, you could cause great harm, for example, the shark incident, or even death. And at that time, insurance is only one aspect, but you certainly don't want to be going to jail. So let's first talk of the Consumer Protection Act. A faulty zip line installation, not very difficult to prove, unqualified guides leading up to activities. These could all have serious repercussions, but I'm only right now under item number 2, I'm discussing Consumer Protection Act. Just a quick overview of who is a consumer. Any person who pays for a service. The trekker, the rafter, the paraglide, but all qualify as consumers of a service. The second is consumers' rights. Each consumer under law of the Consumer Protection Act is entitled to 6 statutory rights. The safety, the right to safe passage through whatever activity he undertakes through that operator. He's entitled to information regarding that activity. He's entitled to make a choice whether to indulge in that activity or not, and that choice must be an informed choice. And he has a right to be heard and seek redressal. And most importantly, he has a right to be educated about what he is entering into. And let me tell you, as an experience, consumer protection fora are very consumer oriented, and they don't necessarily listen to the other side. There's a tendency to be very consumer focused, so you're already in that conundrum. Deficiency of service is also defined in the Act of any fault, imperfection, shortcoming, or inadequacy in quality, manner of performance of a service. Specifically includes acts of negligence or omission, or commission causing injury, deliberately withholding of relevant information to the consumer. Services will necessarily include all recreational and adventure tourism activities. It also discusses unfair contracts, excessive security deposits, unreasonable charges, obligations or conditions which puts the consumer to disadvantages. I'll be discussing a few more of these. You can't be, for example, taking money up front and then saying, okay, now you have to sign this waiver because now you're stuck. And then there are unfair trade practices where you don't provide services of a particular standard. The services have sponsorships or affiliations which the services do not have, and misleading advertisements about safety, etc. So inviting you to do something which you otherwise may not have done would also be covered within the unfair trade practice provisions of the Consumer Protection Act. I quickly went through the 6 consumer rights: the right to safety, the right to information, the right to choose, the right to be heard, seek redressal, and consumer awareness. This is just a further elaboration of that, which I spoke about. And 5 is very important, that you can't bar anybody from going to a consumer forum contractually. So don't think that if you put in a clause that I will not have a liability and you may not have a right to go to court, it doesn't stand in a court of law. Nobody can be denied the right to justice, and contractually you certainly can't bar that out, so don't even think about going there. Consumer courts have 3 hierarchies. Up to 50 lakh claims goes to the district commission, then there's a state commission of 50 lakhs to 2 crores, and above 2 crores the national commission, which is only in Delhi. So there are large, you can see that it is a plus 2 crore jurisdiction to, and it's actually plus means there is no upper limit to the national commission, which is the NCDRC, the state commissions, etc. So you may be saddled, and it's important, if you're saddled with an above 2 crores, no matter where you are, you'll have to come to Delhi. That's another aspect that you need to keep into account when you consider adventure tourism. Just because you're away in the mountains, you can't cut yourself off from Delhi. Then the next item I want to quickly cover is the Indian Contract Act, which discusses exclusions and exemptions. Sometimes operators have a tendency to exclude very broadly. So under the Contracts Act, these are unfair contracts. The contract law generally looks at bargaining power, and contract is based on equal bargaining power. So it recognizes not necessarily what's written on paper, but if there is an unequal bargaining power or knowledge power, then there is the Contract Act recognizes that you must therefore then make the other person come up to somewhat your level so that the contract is considered fair. So in short, if you as an adventure tour operator have knowledge of the risks, and I as a consumer am ill-informed about that knowledge, a duty is cast upon you before you enter into a contract to ensure that you educate the consumer sufficiently to bring him up to explain the contract to him. This then comes on to free consent under sections 13 to 19, and waivers under coercion, undue influence, or misrepresentation are voidable contracts. Voidable means at the instance of the person who has been wronged. A waiver thrust upon a tourist at the activity site after payment, for example, would be a situation where a consumer may go and say that I had no option but to sign because I'd paid a large sum of money upfront, and therefore I wasn't even allowed to withdraw the money, would not constitute free consent, no matter what is written in that contract. And as I mentioned, restraint of legal proceedings is not an option. Then comes, as I said, the shark who eats the leg. So this is now criminal liability, where criminal and civil can go side by side. So you may be saddled with both. And criminal has you typically either jail term or fines, whereas civil would only have damage clauses. So where you endanger life or personal safety, acting rashly, negligently, and you endanger human life or personal safety, if hurt is caused, there's a 6-month penalty. If grievous hurt is caused, then it's up to 3 years. And if that grievous hurt has a causation to your activity, then that could be the obligation on the tour operator. And hurt is defined as, you can see here, emasculation, permanent privation of the sight of either eye, permanent. So, we all know what hurt is, but the Indian Penal Code or the Bharatiya Nyaya Sanhita describes what hurt is. Also cheating, which constitutes a criminal liability, intentionally or deceptively inducing a person to do or omit to do anything which he would not do otherwise, which causes him harm to that person. Explanation of the states, the dishonest concealment of facts. What are the dangers in this rafting activity? What are the dangers in climbing this mountain or conducting this zip lining operation or going down this slope skiing? Sending you down a black slope as a beginner could be a problem. Causing death by negligence, again operator negligence, an aspect quite well understood, also invites criminal liabilities. Now, what are the operator's rights and defenses in this entire operation? So let's look at how one should go about ensuring minimization of risk. Knowledge of the specific task. So it's very, very critical. And all this is recorded, and there are best practices of giving your customer full knowledge of the risks involved in the activity. So and not only telling them what are the safety measures, what could go wrong, what is to be done when you go wrong, and if you are suffering from ailment A, B, or C, what could be the consequence of that? So if you're asthmatic and you're going for rafting, you may be a very good swimmer, but the water is going to be cold. So when you fall into the water, there's going to be problems because asthma may kick in and you may drown as a result of that, though you were a very good swimmer. So these are things which need to be brought out very clearly. So the voluntary assumption of that exact risk by the consumer, you need to ensure as an operator that they have understood the risks and signed up to go for those despite those risks. And you've already asked them for a complete disclosure, which is the next one, that your consent was free, uncoerced of the consumer. No pressures, no tricks. It can't be the first speaker that when I walked in, she said that there was a whole contract, so you can't hand over a 40-page contract and it's in sort of clause so-and-so, somewhere down there, mentioned that this risk was covered and that you accepted that risk. That's not good enough because clearly, when you're going in for an adventure activity, I don't think it's difficult to prove that nobody sat down there and spent 2 hours reading that contract. So if you now notice when you do online, tick of contracts, they make you scroll down all the way and they give you an option of downloading, but you can't accept before you scroll down, which means that you actually took the necessary effort to scroll down, which meant you read it and then signed it. You can't be on top of the contract on a phone and say accept. So all 3 elements are proven, then you're reasonably safe. Then let's look at the Supreme Court said to establish negligence, the duty to care existed, and such duty was owed to every operator, the plaintiff in that case. And therefore, was that duty fulfilled is a question that needs to be answered. When we look at the waiver defense, the test formulated by the House of Lords was a reasonable, foreseeable consequence of the defendant's conduct in the circumstances. So was the briefing to your client a reasonable, foreseeable consequence which you warned the client of or did not warn the client? Was it something which was outside of your control, or was it something that you ought to have anticipated at the initial stage itself? So in the polymus case, it was held that liability may still arise even if the exact sequence of events leading to the damage was not anticipated by the defendant. So even though, because the defendant is not the expert, the consumer is not the expert in what to expect in an outdoor activity. He doesn't do this day in and day out. The operator is expected to do this day in and day out and ensure that he provides the customer with the relevant. For example, in a rafting, there may be a sharp rock which may damage the raft, in which case you have to swim out. But then you have to ensure that your life jackets are appropriate, your safety equipment was fine, and your safety briefing in that situation, what is the customer supposed to do? And then he should be asked to make a call whether he still wants to go. So points to note: knowledge of one's risk is not consent to all the risks. The scope must match the harm exactly. Consent under compulsion is void, and the Consumer Protection Act, unfair contracts will override the exact terms of that contract. One would look behind the contract and the circumstances under which it was signed. Then there are force majeure clauses. For example, you go flash floods, lightning strikes, cloud burst, unprecedented dust storms. Force majeure are normally exempted. So that is something that must be documented if there is an accident as to what was the cause of that accident. Whatever evidence can be led to show that it was a force majeure situation, then you may have to go back in a court of law to show that, look, the briefing was done with all possible foreseeable consequences, but this was one consequence which was not foreseeable. A flash flood happened, or a cloud burst happened, or lightning struck. These are risks that we informed the consumer about, and he willfully took that risk, and therefore I am not liable, and that would be a good defense. Then other operator defenses are contributory negligence. Now, if you see here, the safety briefing was given. I don't want Ajit to be mentioning that the person who's taking that selfie is me. It's often when I went out with him, that was me. Come on, Ajit, it's all right. I'm okay. I can take that selfie. I'm still alive, so I should be okay. And Ajit is not in jail, so I think we're good. And so, despite the safety briefing, the client undertook activities which went beyond the safety briefing or contrary to the safety briefings. Resultantly, the raft flipped or he fell out of the raft. Now, you see the contributory negligence. Slide 1, the operator gave a proper briefing. That's good. Check for the operator. The participant took an unnecessary risk contrary to the security measure that was told to him. He then, as a result of that activity, fell into the water. But now your life jacket was not good enough. So you see, you're sharing the risks. So whilst you did activity 1 very well, which is briefing him, you were also under an obligation to give him a proper life jacket. So because he took this additional risk doesn't mean you become risk-free and your life jacket. So you said if he hadn't gotten up to take the selfie, he would have not fallen into the water and my life jacket would not have come to test. It's not a very good argument, as in any of you can understand, will not fly. So in situations like this, courts would largely hold it to be a shared liability, which is again not the best place for you to be. If you had covered 1 and 4 well, which was you had good life jackets, you gave proper briefings, and your guide did try and control this gentleman, you would probably absolve yourself, and the scale would have shifted more in your favor rather than favor of the consumer. But in a situation like this, it would be a liability of 50-50. Legal documentation is therefore clearly an important aspect which I think this association must look at. I think for each activity there should be templated documentation and templated guidance to the consumer. I think that is something that this organization must provide for each adventure activity. This is the templated document that you must sign, and this is the templated briefing that you must give, and this is the templated security measures that we must give, and also this is the templated security equipment measure that must be used for this activity. I think if you give something like this out to all members who are then made and you ensure that they follow that, you may keep yourself out of courts, which is not good news for me, but it's certainly good news for all of you. So I don't know why I'm even sharing this, but then legal documentation, as I said, so I know that ATOAI already has, and I went through that, so I won't bore you with that because I think this may have been covered by my earlier speakers. But you do ask for indemnities and disclosure forms. There are insurance records, medical records, fictional declarations, participant information records. I think this needs to be tightened a little bit more, where you are able to download documents with clear identifiers of what is where, so that they are educators for all your staff. And it's not difficult nowadays to prepare such documentation, which is the document itself may be very legal, but it has to be understood by your consumer, it has to be understood by your operators. There's liability on you for your staff as well. So this needs perhaps tightening. What a waiver can't do is to say, if you're, there are some aspects of waiver which won't cover, and the second one is clearly that you can't bar access to courts of law. That waiver would not work. He should be asked to sign the waiver willfully before he makes the payment, then after his making the payment. It must cover risk created by operator misconduct. Waiver should not be in an unfamiliar language or too legalese or a 30-pager document. It should be fairly drafted, not with fine print. We discussed about insurance and saying it's only hurt but not, or if you slip and injure yourself, but otherwise it won't cover for HAPE and other forms of high altitude illness. So those are fine prints which need to be looked into. Ministry of Tourism has also published some guidelines which I'm sure have also been covered, so I won't trouble you with those. Insurance and worker protections, etc. It's available on their websites. Just some key takeaways. I know I'm running out of time, but I know this is going to be uploaded somewhere, I assume. So these are just some conclusions. but I've already spoken about them enough, so I don't want to be reading those conclusions, but these are some of the takeaways from what I just discussed in my previous slides. Thank you very much.
Thank you so much, Mr. Lal. I think it's the first time we've had any legal perspective being discussed in our forum, and the adventure tourism's nuances have become such that we all need to understand the importance of the legal documentation. We thank you for it, and we might invite you again.